Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the appraisal contingency if the buyer is getting a conventional loan. Now please browse the channel for other contract tips. What happens if the buyer is getting an FHA insured loan or a VA insured loan, because there are different issues regarding a low appraisal on those types of loans. But if the buyer is getting a conventional loan and the appraisal comes in low, what do? How do you do it to make sure that the buyer is protected on that contingency? Well, the first thing I need to caution you about is that it depends on which contract under which the parties are binding. Very different procedures and documents that must be addressed and attended to if the buyer and the seller are binding on a GAR contract, Georgia Association of Realtors contract, or on the RE forms contract. You guys, in general, if you've ever been to any of my classes, you have heard me repeat this over and over and over. The contract is merely a set of instructions. However, you need to make sure that you read those instructions, both you as the agent, and if you are an actual client or customer watching this, you guys have a responsibility to read those instructions as well. So, if the buyer and the seller are binding under a GAR purchase and sale agreement, and the buyer is getting a conventional loan, then part of that contract is going to be the inclusion of F64, which is the conventional loan financing contingency exhibit. And in that exhibit is where it describes and tells you everything you have to do if the appraisal comes in low. So if the appraisal comes in lower than sale price, first of all, the buyer has a certain time frame within which to make all of this stuff happen. The contract is subject to the property appraising for the agreed upon sale price between the buyer and the seller, and the appraisal contingency is for X number of days from the binding agreement date. And those number of days is negotiated between the buyer and the seller in that exhibit. So if the property comes back and the conventional loan appraiser comes back and the property appraises for less than the sale price, in the GAR contract, the buyer is absolutely required to give the seller the option of selling it for that lower price that the appraisal came in. Now, the exhibit specifically states, if any such appraisal is for less than the purchase price, the buyer shall, within X number of days of the binding agreement date, have the right to request that the seller reduce the sales price of the property to a price not less than the appraised price by submitting an amendment to the sale price to the seller, along with a copy of the appraisal supporting the lower price. In the event that the buyer does not submit the amendment to the sale price to the seller, the buyer shall be deemed to have waived the buyer's right to do so, and this agreement shall no longer be subject to an appraisal contingency. Okay, you guys, what does all that mean? That means binding on a GAR contract, appraisal comes in lower than sale price. Regardless of any communication between the agents, the buyer is absolutely required, within whatever number of days were negotiated, to submit to the seller a copy of the appraisal, and there are some specifics. The appraisal must be done by a licensed Georgia appraiser. Copy of the appraisal along with an amendment asking the seller to reduce the sale price to the appraisal price. And then it goes on further. If there are further timeframes in there, if the seller agrees to do that, the buyer's obligated to continue on with the purchase. If the seller does not agree to lower the price per the amendment, then at that point, the buyer may terminate based on the financing contingency. Again, you need to read through the rest of that exhibit for the timeframes. If the buyer, however, never sends the amendment along with a copy of the appraisal to the seller, giving the seller the opportunity to sell it for the lower sale price, then that appraisal contingency is waived. What that means is the buyer then must proceed to closing at the contracted sale price, even though they got the lower appraisal. So if the buyer's agent and the listing agent go back and forth by emails talking about the appraisal came in low and based on the amount of money that the appraisal came in low, let's say the listing agent said there's no way on earth that the seller is going to sell it for that price. The buyer and the buyer's agent says, well, the buyer's not going to buy it unless the seller's willing to sell it for them. Regardless of any negotiations between the agents, this amendment must be done in order for the buyer to terminate and get their earnest money protected or be protected from not being sued. In the RE forms contract, if you guys are binding on the RE forms contract, the appraisal contingency information is described in the standard terms. And in the standard terms, paragraph 6.2, under the appraisal contingency, it specifically says that subject to any expiration of the contingency, so again, you fill in the time frame, the number of days from the binding agreement date that the buyer and the seller agree to have all of this worked out, that the contract is subject to this appraisal within that time frame. So subject to any expiration of the date of contingency, the appraisal contingency is defined as the seller's grant to the buyer conditional right to terminate the contract if the buyer doesn't receive an appraisal equal to or greater than the sale price. And then it goes on to say that the buyer can submit an amendment to the seller asking the seller to sell it for lower, but they don't have to. Bottom line is, here's the difference. The difference is, well, let me tell you more about the agents before I tell you what the bottom line is. So both sets of contracts, both the GAR, Georgia Association of Realtors contracts, and the RE forms contract specifically state and spell out that agents cannot bind the parties to terms. In the GAR contract, it's in paragraph CK, I think I wrote that down wrong, no authority to bind. And it specifically states, no broker or affiliated licensee of the broker, by virtue of this status, shall have the authority to bind any party hereto to any contract, provision herein, amendments hereto, or termination hereof. And in the RE forms contract, again in the standard terms, where paragraph 11.9.10, it defines parties, and it says each person named in the contract as buyer or seller and shall not include any broker or any third party named in the contract. What that means is any of these notices, any of these amendments, any of this anything must be executed and signed by the buyer and by the seller. Again, email communication between the agents has no bearing on the contract in terms of meeting these contingencies that the buyer and the seller contractually agreed to. So now I'll get to the bottom line. Bottom line is, if you're binding on a GAR contract, conventional loan, and the appraisal comes in low, the buyer either has to buy it at the higher price, or the buyer has absolutely required to give the seller the opportunity to sell it at the lower appraised price by submitting an amendment to the seller along with a copy of the appraisal. All of that must initially take place prior to the expiration of the appraisal contingency. If the buyer does not send that amendment to the seller and terminates on the appraisal contingency based on communication between the agents, the buyer will have defaulted on the contract if they are terminating based on that and they didn't send the amendment. If you're binding on the RE forms contract, conventional loan, appraisal comes in low, under that contract, the buyer absolutely may terminate without giving the seller the opportunity to sell it for the lower appraised sale price. So make sure that you know what the rights, responsibilities, and consequences are for the buyer and the seller with respect to a low appraisal on a conventional loan that the buyer is getting, and read the instructions per your contract, because very different things that you have to do if the parties are binding under GAR and RE forms. Hope that helps you guys. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.